Hello, my name is Karen Harding and I'm a criminal defence lawyer from New Zealand. I'd like to take this opportunity to talk to you about solution options for achieving safer communities and to introduce to you the concept of SSP, which is Smarter Sentencing Programs, to move us along to smarter sentencing. Now let's just discuss the broad-line concepts. There is a growing recognition among professionals engaged in the justice system that change is needed to more effectively deal with recidivist low-level offenders who commit the disproportionate number of offences. This requires reducing the precursors to crime and opportunities for offending. The justice system needs to be smarter, with a comprehensive range of sentences available, including appropriate and readily available treatment and reintegrative programs. A tool to achieve smarter sentencing is to use Smarter Sentencing Programs, SSP. Another tool is to expand diversion opportunities. More emphasis on youth justice is required. A means of reducing recidivism is to enhance judicial supervision of offenders with drug, alcohol, family violence and mental health issues. A cohesive political response and collaboration as opposed to a silo approach between government departments, courts, helping services and other justice stakeholders is required. Otherwise, more of the same will be produced. Good policy in justice requires interdisciplinary activity. A holistic approach to law and legal practice involves empowering individuals to resolve all aspects of their legal problems, including the behaviours manifesting as criminal offending due to dysfunctional behaviour. In a narrow context, a holistic approach favours addressing all litigants' legal problems at the same time. A broader approach regards legal problems as being interrelated to psychological health and other life issues, which may require a lawyer to apply therapeutic jurisprudence-based principles when enacting with a litigant and referring a litigant to other professionals to address their needs. There is a focus on emotional healing. Holistic approaches involve a greater emphasis on the quality of the relationship between the lawyer and client or judicial officer and litigant, and the importance of interpersonal skills in promoting legal and related outcomes. It involves an interdisciplinary approach to legal practice that requires adopting ethic of care principles and research-based therapeutic jurisprudence strategies based on sound theoretical premises and evidence as to efficiency. Embracing therapeutic jurisprudence as an underlying justice doctrine can enable processes to be developed that can act as a therapeutic agent to maximise psychological and physical well-being. Therapeutic jurisprudence is the study of the therapeutic and anti-therapeutic consequences of the law. Where litigants feel satisfied with court processes, believing them to be fair, they are more likely to comply with court orders and respect the outcome of judicial decisions, improving the integrity of the justice system. It is a tool that can be utilised to involve increased participant satisfaction with court orders. Therapeutic jurisprudence is the framework beneath the problem-solving justice utilised in specialised problem-solving courtrooms and in mainstream courts. It draws on research from the behavioural sciences. We're now going to go on to discuss Smarter Sentencing Programs, SSP. Smarter sentencing is the new buzzword in criminal justice. Well, it's not in New Zealand, but it is elsewhere in the world, and I hope to introduce it here in New Zealand. Smarter sentencing is defined as the use of research and science to enhance the decision-making ability of criminal justice stakeholders in the selection and application of fair, just, proportionate and effective sanctioning goals. Getting smart on crime involves relying on science and data to shape policy. SSP utilises research-based practices by applying high-quality research practices to the sentencing of criminal offenders to reduce recidivism rates through the more effective management of offender behaviours. Sentencing in traditional courts largely depends on the criminal history of an offender. Smarter sentencing programs involve using objective scientific instruments to assess an offender's needs and risk of recidivism and fashioning a sentence accordingly. Smarter sentencing programs rely less on incarceration, thereby decreasing sentencing costs and creating surplus for alternative sentencing measures to be developed. Smarter sentencing programs is a tool to target moderate to high risk offenders, focusing on their criminogenic needs. Low-risk offenders require less intervention because recidivism among low-risk offenders increases when they're included in programs with high-risk offenders. The risk of each offender needs to be accurately assessed using an actuarial tool and professional judgment. Risk assessments are then used to inform plea negotiations, sentencing and breaches of court orders. The imposition of unnecessary conditions of probation beyond those directly related to an offender's needs and risk only serves to impede and distract offenders and corrections. Congenitive behaviour programs are effective at reducing recidivism. Offenders tend to behave in ways that result in the most reward. Consequently, smarter sentencing programs use both positive and negative incentives. Positive incentives have been found to be more effective than sanctions. Smarter sentencing programs can involve an offender's family, and smarter sentencing programs focus on tailoring individual treatment to meet the personal characteristics, needs and motivation of offenders. The aim is to allocate resources more efficiently and to achieve crime reduction through intelligent judicial decision making. Smarter sentencing programs require enhanced information on individual offenders and explores options for dealing with risk in the most fiscally responsible manner. One of the biggest costs on the justice system is the persistent offender. Smarter sentencing offers an opportunity to divert offenders from criminal careers, lowering recidivism rates. In Davis County, Texas, our SMART program, providing a sentencing alternative for substance abusing offenders by providing intensive substance abuse treatment and offender resocialization in a community setting. It is a community corrections based program for adults, and it offers residential and continuing aftercare services. The offender is required to pay a maximum of $1,400 US towards treatment. Admission criteria involves eligibility screening, a court order for participation, and offenders must have an advanced alcohol or other substance abuse problem. Only medium to high risk offenders are accepted. Offenders who have exhibited a propensity for violence are excluded, as are those diagnosed with psychopathy or pregnancy. It involves a 20-week residential program with group counselling, employment training, specialised groups for women and congenitive therapy. The program involves a follow-up relapse prevention and counselling for 6 months. So, you can say to your offender, you need to go on smart sentencing, and the offender can say to mum as he goes off to corrections, I'm off to smart court for my smart sentencing program. Let's be smarter people and move on to smarter sentencing. Union County in Arkansas has a smarter sentencing program operating in its felony court jurisdiction. It incorporates the practices that include the National Drug Court model. It utilises the Ohio risk assessment system. Offenders are divided into risk tiers. Low risk offenders may enter the smarter sentencing program without entering a plea of guilty. Moderate to high risk offenders are required to enter a plea of guilty upon entering the program. Upon completion of the smarter sentencing program, the sentencing judge can either dismiss the charges or place the individual on probation. Offenders with low risk can enter the program before charges are filed. Union County has the largest smarter sentencing program in the estate, and their program has been evaluated, showing program retention is high. The Arkansas Smarter Sentencing Program is administered at half the cost of incarceration. A similar model to smarter sentencing has proved effective in Finland, which has the lowest incarceration rate of European Union countries at 57 inmates per 100,000. Now really we need to compare this to New Zealand because our imprisonment rates are second in the Western world after the United States, appalling really in terms of statistics. And when we look at our Maori offenders, they're getting locked up a rate of 634 per 100,000, and that's just our Maori population. So at 57 inmates per 100,000 in Finland, and they have a very low crime rate, they are doing something very right, and we need to stand up and listen. The Finland Criminal Code emphasises general crime prevention through the reinforcement of moral and social norms. The punishment is focused on value shaping instead of retribution. This is our main problem with our New Zealand justice system, is it's really focused on retribution. You know, lock people away for longer, even though it costs $96,000 per person to lock them up. They don't get enough treatment in there, and they come out and they just repeat all the same patterns. And we're locking up low risk offenders as well for that huge cost, when really they might need some other kind of intervention to turn them around. So the Finnish system is really worthy of serious consideration by the New Zealand justice system, and I encourage you to look into it yourself a bit further as well. So the options in Finland include conditional imprisonment. So that's very similar to the New Zealand abolished sentence of suspended terms of imprisonment, which we don't have. So that allows something to hang over someone's head, that if they are to reoffend within a certain period of time, then they're going to go to prison. So that does encourage people to be very good in their behaviour, and that can be supplemented with community work and programs and rehabilitation and making restitution to victims. Some Finnish prisons are open prisons, so they have closed and open prisons. An open prison is an institution without walls, so there's basically no fence. And the prisoners wear their own clothes. They undergo a minimum of stigmatising symbols and discipline. What is interesting is that they participate in work, and then their wages come to pay for their board, so their wages are paying for their food and their accommodation. So they're being re-socialised within a sort of a prison context in a supervised way that takes them away from the general community, but they work, participate there, and they're being fiscally responsible. It is an option that we should consider for some offenders, and it is a bit more fiscally responsible. Of course, it has to be in the right location to make that work, so that then you're not running off all over the place. So there are some open prisons in the United States, generally tending to be near the desert. The Finnish system also offers victim and offender mediation services and as an alternative to the traditional sentencing process. So that is your restorative justice, which has also been regarded as very effective to dealing with a lot of the crime issues there, because it leads to accountability, taking responsibility and making amends. And it is a more fiscally responsible sentence as well. And it's very important for New Zealand to think about these fiscal responsibility issues, because together the police, justice and corrections are spending more than $3 billion. And that is making a huge impact on our fiscal budget, and we're in a deficit. And of course, corrections had been growing so big that it was heading towards becoming our most monster department. So what are we doing in a country where corrections is our largest department? Can you imagine that? Why? We need to do something better, we need to change. So smarter sentencing options give us a chance to reevaluate how we do things, and it's research based in terms of what is effective for people with those characteristics on those type of charges, and based on their actual risk, using an actual risk assessment. So I hope you found that reasonably interesting, and I look forward to sharing some other information with you. Thank you for your time.